Thank you. Thank you. Thank you.
Second, I'd like to thank all of the students on ACS and FedSoc who worked really hard all semester to organize this event. My partner in crime, Sarah, for busting her butt to really bring this together. She put a lot of hard work into this. Anything else?
Same goes for you, Haley. We really appreciate all your hard work. And thank you to Professor Davies for agreeing to moderate. For those of you still in the back, continue to grab food, just do so quietly, and we'll get underway.
Thank you very much. A couple of quick comments before we get started, just to give you a sense of where the moderator stands, because you all would want to know, of course, if you had a biased moderator, and so I will disclose a couple of my biases up front that will sort of put you on notice of the direction in which this may tilt. Josh Blackman is a former student of mine.
I am.
Yes.
I went here.
And he passed his class that he took with me. So,
I got an A.
So, Mike Seidman is, in my opinion, not only one of the leading critics of originalism, but without a doubt the most articulate critic of originalism. And so, as much as I love Josh, my protege, I fear for him.
I'll see what I can do.
Then again, I've had him in class, so maybe I shouldn't fear for him. But this should be both a great education for all of you and for me, and also great fun, because we have first-rate scholars and advocates for both originalism, although there are several varieties of originalism. Right? It might, in fact, be thought of as the Neapolitan ice cream.
The umbrella. There's an umbrella.
So in any event, we have a lot to learn about originalism, about its arguments both for it and against it, and what it means or might mean. And yet we also have to be out of this room in 55 minutes. So here is the plan. We are going to have 10 minutes from Mike Seidman, then 10 minutes from Josh Blackman.
Oh, he goes first. Oh, okay. I thought I was going first.
No, you bet I go first.
Okay.
Oh,
That's fine. I go first. Okay.
Yeah.
We flip
okay,
it.
you two go right.
Okay.
That's
That's fine.
I don't get to go first.
That's fine.
Okay.
He goes first.
Sarah?
So usually
Where's
the person
Sarah?
making the pro goes first, but he'll be making the pro
We can
anti-constitution.
spend our time.
No, he goes first. Let him go first. That's fine.
I think what we're talking about, it depends on how we see. This is the fun of this. Okay, Mike Seidman, I am sure, strongly believes he is making a pro-constitutional presentation.
A pro-anti-constitutional interpretation.
See what I mean?
The clock is running, Kevin.
Mike, you go first. That's fine.
So we're going to have 10 minutes from Professor Seidman, then
Okay.
10 minutes from Professor Blackman. Then, in the spirit of fairness and balance, I have 2 questions from the Federalist Society and 2 from the American Constitution Society. And then, in the available time left, we will take short, crisp, on-point questions from the admiring audience. And with that, Mike Seidman.
Well, thank you, Russ. That was very nice of you, and thank you for. Okay, thank you for inviting me to this debate between Chick-fil-A and.
No one got stabbed.
I am. I have to say, I'm a little intimidated about attacking originalism in the shadow of a larger-than-life statue of Justice Scalia. I've heard people refer to him as a giant in the law, but I didn't know it was taken quite that literally. I feel a little like somebody going to Fenway Park to root for the Yankees. But one thing that Justice Scalia loved was vibrant debate. So I'm sure he would be happy with this event. I have to say it's and I mean this seriously, it's too bad that there's no one on your faculty who has anything like my views about this. But I'm grateful to you for inviting me here to express them. So one way to establish a successful academic movement is to provide a research agenda for professors to follow, and at least in that sense, I think originalism has been quite a successful academic movement. So we have okay, is that better? We have a growing body of increasingly arcane and scholarly work about originalist theory plumbing the depths of linguistics and positivist jurisprudence and investigating questions like the limits of pragmatic supplementation and exactly what H.L.A. Hart meant by the rule of recognition. For me, the debate about originalism is really much, much simpler than that. My colleague, Jerry Spann, summarizes it with two questions. How would we know, and why would we care? That's the way I want to organize this, and I want to address first the question, why would we care? So the American Constitution is perhaps the oldest in the world and the most difficult to amend. It was written by some very smart people, but they were also people who have been dead for over 200 years, and who I think it's fair to say knew virtually nothing about our current circumstances. They were writing for a tiny, mostly rural nation that was huddled along the eastern seaboard. They knew nothing of the internet, indoor plumbing, atomic weapons, Al-Qaeda, global warming, or the Kardashians.
Good.
And they had some very strange ideas. Many of the most important participants in the Philadelphia Convention owned other human beings. George Washington brought a slave with him to Philadelphia to take care of him while he was writing the Constitution. These were people who thought that women, people of color, people without property, all of those people had no business being involved in public affairs. The document they wrote was almost certainly opposed by a majority of Americans at the time it was written, and no one alive today had any role at all in writing it. Indeed, not only didn't I have any role, my descendants had no role. They were wandering around someplace in Eastern Europe at the time. So Thomas Jefferson famously and rightly said that the past is like a foreign country to us. No one today would say that the United States should turn over control of our country to, say, France or to the United Nations General Assembly. But France and the UN General Assembly, in important respects, actually have more in common with us today than the framers did. So the basic fact is, this is our country. We have responsibility for it. We are the ones who have to live in it. We have the right to have the country that we want, and not the kind of country that folks who've been dead 200 years ago wanted. It does not make any difference to them. It makes a lot of difference to us. It turns out then that, and this is a strong claim, but I'm going to defend it, originalism is a kind of authoritarianism. It's a way of saying that people alive today don't have a right to have their own country, and that the people who favor originalism don't have to offer reasons for their position. What they were saying in effect is, you have to accept this whether you want to or not, and whether there's a good argument for it or not, because some folks 200 years ago thought it was right. So let me take a specific example to illustrate this. It's an example that was near and dear to Justice Scalia's heart, and that is the Second Amendment. Most of my friends, and certainly my spouse and my kids, are shocked and horrified when I tell them that I'm actually quite skeptical about gun control. I think that most of the measures that are being proposed are not likely to be very effective, and that they disrupt strong cultural and traditional practices without accomplishing very much. So I don't know that I'm really for it. But I do recognize that many smart people disagree with me, and in a well-functioning republic, what we would do is talk calmly and respectfully with each other about that disagreement. But what happens when one part of the conversation, one person is an originalist? Well, then the conversation goes something like this. You say, gun control is a good thing because it would save a lot of lives. I, the originalist, say, well, maybe that's true, but I really don't have to answer your argument because the fact is, according to the original public meaning of the Constitution, gun control is unconstitutional, and that's the end of the argument. So notice then the first thing that happens. The first thing is the temperature of the argument gets raised. Now, instead of disagreeing about some social science study about the effect of gun control, we're talking about who the real American is, right? Who is it who supports our Constitution? And that gets people angry in a way that they don't get angry about some social science evidence. But beyond that, after I make that move, how are you supposed to respond? So you have a choice, and neither choice is very good. You can say, well, screw the Constitution, I'm still for gun control. But if you say that, you're immediately discredited in our culture because you're not supposed to say screw the Constitution. So what's the only other thing you can say? You say, you're wrong. The Second Amendment doesn't mean that. And what happens when you say that? We start talking about the issue the way lawyers talk about it. So instead of talking about what really matters, does gun control save lives? Do people have a right to self-defense? And so on. We start talking about the relationship between the prefatory clause and the operative clause, and about whether the framers meant to incorporate the Bill of Rights into the Second Amendment. So what have we done? We've not only raised the temperature of the discussion, we've also changed the subject to matters that are profoundly irrelevant about whether we ought to have gun control. So that's why we shouldn't care. But let's suppose I'm wrong about that. We do have a second problem. How would we know? Now, to their credit, many modern originalists have sort of fixed up the theory, and they've made two moves that make the theory more plausible. First, they've abandoned, or many of them have abandoned, what's sometimes called expected application originalism. So the question they say is what the words meant, not how people might have expected the words to apply. Maybe the framers of the 14th Amendment didn't expect the words to mean that racial segregation violated equality, but we now know that it does, and we ought to enforce the meaning of the words equal protection and not what they happen to think how the words might be applied. And second, many of them have recognized a distinction between interpretation and construction. So what many say is we should fairly interpret the words of the Constitution according to their original public meaning, how an average person would have understood them at the time they were written. But sometimes the words are vague, ambiguous, or open-textured, and when that is true, interpretation just runs out. It doesn't give us an answer, and so we have to do something else. We have to construe the language. We should construe it in a way that doesn't contradict the original public meaning, but the original public meaning doesn't determine the outcome because the words are just too vague or ambiguous to do that. Okay, so that's an improvement, I think. Things have gotten a little better. But the trouble with those moves is that if you take them seriously, there's really nothing left of originalism. And that's so because once one abandons expected application, and once one recognizes the difference between interpretation and construction, virtually everything turns out to be in what's sometimes referred to as the construction zone. So to see how this works, let's talk about the Second Amendment again. What was the original public meaning of the right to bear arms with regard to, say, an AK-47? Now, One might think the way you're supposed to answer that question is by imagining James Madison. So we go and dig him up from his grave, we shake him a little to get him alive again, and we show him an AK-47 and we say, Jimmy, is that what you meant by the right to bear arms? But most modern originalists, I think, would reject that formulation, and for a good reason, and the reason is, who knows what he would say? I mean, if James Madison knew about AK-47s, I don't have the foggiest idea what he would say about that. So what do originalists do instead? Well, they do what Justice Scalia does. They consult dictionaries of the 18th century, and they try to determine what the word arms meant in these dictionaries, and then they see whether AK-47s fall within that definition. But I think it's easy to see why that is not a sensible approach. The writers of the dictionary were reflecting usage then, which simply didn't take account of modern armaments. So actually, Justice Scalia himself offers a good example of this in his writings. Again, a case involving guns. While he was on the court, he had to interpret a statute that prohibited the use of a gun in a drug transaction. And what the defendant had actually done was trade his gun for some drugs. And Justice Scalia said, that's not what the language means, and he voted to reverse the conviction. Now, and he says, look, it's true, if you look up the word gun and use in a dictionary, the word use covers what he did, and the word gun covers what he did. But he says there, that's not the right way to do it, because whatever the dictionaries say, this is just not what ordinary people would take it to mean when you say use a gun. Well, fair enough, but you can say the same thing about AK-47s. People in the 18th century did not know anything about these weapons. It's a little like asking whether they thought computer games were covered by free speech. Who would know? So an AK-47 might fit the dictionary definition of an arm, but the question is, what would they have thought if they were told the right to bear arms means the right to hold an AK-47? It's entirely possible they would have said, no, that's not what we meant at all. We just didn't have that in mind. Okay, so that's a problem with AK-47s, but let's make things a lot easier for originalists. Suppose someone is walking around not with an AK-47, but with an 18th century musket. Okay, exactly the thing the framers knew about. So surely that comes within the meaning of the right to bear arms. But actually, even in that very unusual situation, it's subject to the same problem, because the framers thought about the right to bear arms in a rural, uncrowded country that actually lacked an organized police force. If you presented them the question of whether you ought to have a constitutional right to have a musket in modern America, I just don't know what the answer would be. They might say yes, they might say no. So it turns out, for that reason, virtually any interesting case is in the construction zone, and originalism just doesn't help answer the question. We just don't know what the language would have meant to people had they known the situation now. So for all those reasons, originalism is not, I think, a very attractive theory. The ultimate question we need to ask and answer about constitutional interpretation is it going to make the country a better place? And it seems to me originalism is not likely to do that. That's true. But I have to say we don't have a real test of whether it's true, because of the fact of the matter is there is no one on the Supreme Court today who is an authentic and consistent originalist. So let's take, for example, Justices Scalia and Thomas, the two recent justices who most frequently invoke originalism. I would describe both justices as kind of fair weather originalists. They do it when it serves their purpose, but not when it doesn't. There were many examples, but I'll just quickly focus on one. Affirmative action. To my knowledge, well, Justice Scalia was, and Justice Thomas is, a very firm opponent of affirmative action. To my knowledge, neither justice has written a single word about the original public meaning of the 14th Amendment with regard to affirmative action. What have they said instead? They've said things like affirmative action is toxic because it encourages race consciousness, that it's unfair to white people, that it treats black people with condescension. In other words, with regard to affirmative action, they're living constitutionalists. They're looking at policy and whether this is a good thing to do your day. So what in the end does originalism amount to? It's not actually a theory that the Supreme Court applies or indeed could apply. It's not really a practice. What it is instead, I think, is a phony justificatory ideology that has no point of contact with what courts actually do or what they could do. And it's a mark of how hypocritical our justificatory frameworks really are, and therefore it serves to discredit those frameworks. For people who authentically believe in those frameworks, the rhetoric of originalism is an embarrassment, and it ought to be abandoned. And I'm just sure that you agree with every word.
Should be embarrassed. Got it.
Yeah. Thank you very
Got
much.
it.
And now, Professor Blackman, you're on.
I'm not embarrassed one bit. Thank you, Mike. This is healthy. Usually when I go to a law school, there's no one there to take my view. But at Mason, my alma mater, there's no one to take Michael's view, so it's a good place to be. Indeed, I debate all the time. We had a debate at Georgetown 2 years ago on free speech, and it was very robust and very...
Clock cleaned, I should say.
Oh boy, yeah, no, we had a fun one at Georgetown, but now he's on home turf, so I can use a home field advantage. I am not embarrassed, not in the least. Let me start off by giving how I understand originalism, and then I'll respond to some of Mike's cogent points. The core idea of originalism is very simple. Courts should be bound by the original public meaning of constitutional text. The meaning of text has a public meaning, the ordinary or plain meaning the words had to the public at the time the provision was framed and ratified. The original public meaning of the text is the meaning the words have then and have now. I'm sorry, that had then, but not the words meaning they perhaps have now. The court should consider itself bound by the text. It doesn't always approach this. And one of the difficulties of defending originalist judges is they often deviate. Now, I agree with Mike on one important point. I think Thomas and Scalia have been utterly indefensible on the 14th Amendment original and affirmative action. If you go back to the 1860s, there was an agency called the Freedmen's Bureau Act. You ever hear about that? If you have my Conlow case book, it's in your book. We had an entire government agency created to help the freedmen reacclimate themselves to society after slavery. That sounds a heck of a lot like affirmative action to me. So I've never seen any good originalist defense of the Scalia-Thomas line of jurisprudence. I'll agree with Mike on that. But I say this as a point that originalist judges aren't always originalists. And I don't feel I have to defend them. I criticize Scalia, that giant of the law standing in the lobby at length. I think his opinions in McDonald and other cases are very tough to defend from originalism grounds. He was not perfect. He had sin, as we all do. But let me talk now about how I view originalism and why I think it's defensible, not a phony justificatory framework. Did I get that right, Mike? I tried typing as fast as I could. I've never used the word justificatory before. I didn't know it was a word. Justificatory, did I say that right? Justificatory.
You should have written it down.
I typed as fast as I could. Maybe I'm an embarrassment, I don't know. Originalism, my friends, is not new. Alexander Hamilton, the great Broadway superstar, told us in 1791, whatever may have been the intentions of the framers of a constitution or of a law, That intent should be sought for the instrument itself according to the usual established rules of construction. And what was that rule of construction? It was, what did the words mean at the time they were ratified? And I give you Hamilton, Jefferson, they all said similar things. Now, I want to walk through some of the common myths of originalism, and there are a lot of myths. One, originalists are not trying to channel James Madison, holding a seance and asking James, Jimmy, tell me, my friend, what did you think of the AR-15 or the AK-47 or internet porn? What did you think of these things? Don't ask him that last one. What did you think about these things? Originalism is about constitutional text. We don't ask what would James Madison do. We don't have a little Ouija board where we get Scalia and Thomas in a room and start moving. That's not what we do. What matters is what the text says, right? The original public meaning has an established meaning. Michael alluded to one way we look at meaning. It's called corpus linguistics. How many know what that is, corpus linguistics? Okay, a couple hands. Corpus linguistics, there we go, is like Google for original meaning. We have this huge body of evidence from the founding era. We search and statutes and pamphlets. Right? Dictionaries are flawed. I agree with Michael on that one. Why? They're all plagiarists, right? All the dictionaries are each other. So you have this reinforcement of words that just don't have meaning. With corpus linguistics, we defeat that. I have a paper on Heller and corpus linguistics. You want to know what I do, Michael? I criticize Scalia. I think Scalia got some stuff wrong. But Scalia was not a little angel on this front. There was my diploma doesn't say Scalia, so I'm allowed to knock at him. The second myth of originalism is that originalism cannot apply the Constitution to new circumstances. I just don't see this as working, right? We have to understand what speech is. And whether you're speaking on a pamphlet printed on a printing press, with a quill, with a microphone perhaps, with an email, you're engaging in the same sort of act. And I think judges can apply these phrases to acts where we are today. Nebraska was not a state when the Constitution was ratified, but there's no problem saying Nebraska gets 2 senators, right? You can apply text to these sorts of circumstances. The third myth, and I'm surprised you didn't mention it, is Brown, right? The most canonical case of the 20th century, Brown versus Board of Education. There's a section in Brown where Chief Justice Warren says, we've tried to look at the intentions of the framers of the 14th Amendment to see if it sheds some light on the segregation question. And then Warren says, I'm paraphrasing, it wasn't very helpful. I think that was more or less his phrase, I'm paraphrasing. It wasn't that it wasn't helpful, it's that the originalism he had said segregation was okay. That was the opinion in Brown, but there's been a lot of debate after this, and I mean it's a vigorous debate, about whether the notion of segregated schools is consistent with the 14th Amendment. I won't try and resolve it for you, but there's a very good back and forth between Michael McConnell and Michael Klarman where they debate this issue. And you can pick your own side, but I can assure you originalists do think that the idea of segregated schools is inconsistent with the privileges or immunities of citizenship of the United States, and I'll leave it there. But I think you can have a theory of originalism and reach the same result in Brown, but for very different reasons. Another myth is that originalism is inconsistent with precedent. And I think this is a very forceful argument concerning stare decisis, right? We have all of these arguments about, we have all these opinions that were in no sense originalist. How is an originalist supposed to deal with them? Well, for most judges in the lower courts are stuck with them, right? A lower court judge cannot ignore a Supreme Court precedent any more than they can decide a case by flipping a coin. They're bound. Okay, now what about the Supreme Court? Even originalists on the court, Justice Thomas, for example, suggests that stare decisis weakened in constitutional cases, but they will still generally follow precedent to a point. And I'll use this phrase that my colleague Randy Barnett and his colleague as well at Georgetown uses, this far but no farther. You can acknowledge that the past precedents are wrong, and because there's some reliance interest, you keep them in place. But you decline to extend the precedent to new contexts that are not justified by the original meaning of the Constitution, right? So in other words, you sort of stop the bleeding, right? You say, okay, stuff was bad in the past, we just don't extend it. Or to use an example you might know from torts, if there are 3 houses in a row and the first one's on fire, right? To save the other 2, demolish the middle one. Remember this one? Yeah, kind of like that, but just stare decisis, right? You leave the bad stuff in the past, but you just don't extend it further. Okay. Myth number 5, and this is perhaps, I think, the most common myth, and it's one that Michael alluded to earlier, is why should we favor a document that was ratified by white, slave-owning men who disenfranchised most of the population and had antiquated views in every social issue we can think of? Okay. You have no objection from me. The Constitution was written at a time where white people were basically owning other white people. And I can't, he's right. We have had, my friends, 2 foundings. I think it's a mistake to think of the Constitution as founded only in 1787. We had a second founding. You all know James Madison and Alexander Hamilton. Who here knows John Bingham and Jacob Howard, right? Who knows a name like Lysander Spooner, right? Yeah, he knows. These are people who had constitutional thoughts after Philadelphia, right? Our Constitution was not frozen in place. And when we get to the Civil War, there was a very sharp division about constitutional thought, right? There was one school of thought that believed that people of African descent were inherently inferior, and they can never be citizens, and they were always inferior. And the leading proponent of that view is Roger Taney, right? And Taney said the Constitution was a document that endorsed slavery at its heart. And then, as a result, Dred Scott came out, such that Dred Scott could not be a citizen of the United States no matter what he ever did, free or not. And there was another perspective about this question. People like Lysander Spooner and others argue that the Constitution was silent on slavery. It said nothing at all, right? It used phrases like other persons or persons held in service. And this was a deliberate choice. The Constitution said that people cannot be deprived of their liberty without due process of law. Now, in the debate in Dred Scott, Taney won. I think he was wrong. I think most people agree Taney was wrong. But then we fought a civil war largely over that question. Who was right, Roger Taney or Lysander Spooner? I'll tell you something. Spooner won. Frederick Douglass prevailed, not Roger Taney. Roger Taney got his ass kicked in the court of history. And we enacted the 13th, the 14th, and 15th Amendments in fairly short progression, which abolished slavery, guaranteed equality and privileges for immunities under law, and granted the right to vote to the freedmen. That was your second framing. And then we had more amendments. We had amendments over suffrage. And by the way, even before the suffrage amendment, in some states, women were allowed to vote. In fact, at the time of the framing, fun fact, unmarried women in New Jersey could vote at the time of the framing. Google it, it's true. Then we had the ratification of the suffrage amendment. Hell, we maybe get the Equal Rights Amendment. You guys, Virginia, I mean, this is ground zero. We may get a 28th Amendment in the next couple of years. I have thoughts on that. I'm not sure if the extension's valid, but we may get the Equal Rights Amendment. So there are ways of changing the Constitution after its enactment. We are not stuck in the past. It's hard, but not impossible. Ultimately, though, I think Michael's objection comes down to what's called the dead hand problem. That is, why should we be governed by a bunch of dead people? He says, is this going to make the country a better place? That's the question. Michael's argument is not so much a criticism of originalism. It's a criticism of all written constitutions, right? Anything he says will apply to a document older than 50 years or so, right? If the idea is, did we play a role in shaping this document? Okay, we're all here, whatever age range, 20, 30, 40, 50, right? We're all gonna die soon, right? You know, we're not gonna be here forever. We're all gonna die. I know, very uplifting. Eat your Chick-fil-A, Popeyes, enjoy it, YOLO, right? Just go for it, right? But we're all gonna die. And at some point, our work will be forgotten. But when you pass a statute of any kind, we presume that it'll be in effect forever. Some statutes are pretty old. For example, the Civil Rights Act of '64, very important statute, enacted in 1964. Who here was alive in '64? Sorry. Exactly. Why are we bound by your law? Why should we be bound by your law that you enacted? I had no role. My parents were kids at the time. My goodness. I set him up.
Listen, buddy, I was alive in 1860.
That's right. He was John Bingham's roommate.
Right.
He was the radical Republican. But why are we bound by laws from your generation? I don't know. I wasn't that. Why should we care? We have a Supreme Court case now about Title VII, about what does the word sex mean on the because of sex, right? We have questions of meaning in every single aspect of our polity. But at the most basic level, we are all governed by the dead hand of one another. Thomas Jefferson said something else. Jefferson said we need a new constitution every 20 years. Maybe that's the answer, right? Maybe just have a, God, Lord help us. People drafting constitutions on Twitter, we're screwed, right? It'll be Article 1, TikTok, it's going to be really bad. But we need to understand that all laws written, the UCC, why are we written years ago, the Restatement Second of Contracts, why are we bound by what they thought of consideration? We are bound by law because that's what the rule of law is premised on, a written constitution which we're bound by. Now, last point. I think his criticisms of originalism are quite good, but you should ask him what's the alternative, right? What do we go with if we are not originalist judges, right? We have a judge, there are 9 members of the court, they have this little booklet here. People will go to the court and say, right to gay marriage or right to bear arms, right? What is a judge supposed to look to if not the original meaning? His personal philosophies, the sweet mysteries of the universe, to quote Justice Kennedy, right? Emanations and penumbras. I've seen a solar eclipse. There are no penumbras in my constitution. It doesn't light up like a Harry Potter book. What do we look to? What's the alternative? And maybe that Justice Scalia was right. It's the least worst approach, right? For all the failures of originalism, it has attributes and benefits that other things just don't have. I think that is the greatest defense of what I believe in, and I'm grateful to give this presentation in the shadow of our great Antonin Scalia. Thank you.
Thank you.
Well, you have such great
No, ask them.
questions.
It's fine. The questions.
Yeah, because we are going to run out of time. So how should we spend our remaining time? Do we want to spend it on what these people want to know? What's that?
Couple-minute rebuttals maybe, and then.
They don't need to rebut.
If Michael wants
These
it.
arguments were so weak, I don't.
I think these folks are sufficiently clever.
Yeah,
that
we
they can
can-
weave their
Yeah,
rebuttals into
we can do that. That's fine.
How's that?
Yeah, so I prefer student questions are good. Do these.
Yeah, student questions.
Okay, student questions. Seeing no questions.
No, do those. No, Ross, do these. Do these. The format got blown up today.
They
You're-
want our questions, I guess.
Yeah, do these.
All right, we'll do these. Okay. These are
Which
these
were
are
voted and
great
approved on. Good, democratic. I like it.
Was there a vote?
No, I
Okay.
single-handedly chose.
Okay, so this is an authoritarian process. So, one argument is that we should not, about originalism, is that we should not interpret the Constitution using originalism because it was written by a small group of older white men.
Oh, yeah.
Currently, the judicial system in this country is bound by small groups of mostly white men, including on the Supreme Court. Is this also an argument for getting rid of stare decisis? If so, will our judicial system become unpredictable? I think we should limit, to get through these,
Who is
2
that
minutes.
directed to?
It's to both of you.
Ross,
These
you
are
want to
all
decide?
to both of you.
Ross can decide. I don't
Yes,
care.
so 2 minutes apiece on this. Who would like to go first?
Michael, you can go first. Payback.
Okay.
Yeah, think about it. There it goes. Yeah.
So, I think that that's a good question, and it feeds into the question of what you would do other than originalism. First of all, I do think the bench ought to be more diverse, and it certainly is more diverse than it was at the time of the framing. But the basic point is this: as Josh conceded, there's no one on the Supreme Court now who is anything like a consistent originalist. So if the question is, what should we do? One answer would be we should do what we're doing now, right? And I have noticed that the country's collapsed because the Supreme Court does what it does now. If we're going to be really honest about it, what the Supreme Court does now, it's not originalism. For the most part, what we have is an elite body that decides according to elite principles questions about how the country ought to be governed on at least some matters. And what I'm actually in favor of is we ought to be honest about that. So all of the justices, liberal and conservative, ought to fess up to what they're actually doing And then the American people can decide whether that's something they want done. And if it was put honestly to them, I think Americans might well say that's not something they want done. I'm sort of agnostic about it. I think there's something to putting some checks on popular democracy by elites, but I'm agnostic. And ultimately, I think the people ought to decide that, and if it's something they don't want done, the Supreme Court ought to stop deciding constitutional cases. That's all. And they ought to just adhere to majoritarian institutions. Josh?
I agree with the last part. If we abandon originalism, then I think the courts should get out of the business of judicial review, which is not what he said. This is the last part I agree with. Right, if I am a justice in the Supreme Court and I'm presented with a constitutional case, and I base it solely on my own sense of philosophy or what I think is the right answer, the best answer, I have no license to act. Right? Judges don't take an oath to, some philosophy book. They take an oath to the Constitution. If we want to be honest, and they're saying we're not basing this on the Constitution in any meaningful sense, then get out of the business of judicial review and just defer to democratic processes. I favor a new constitutional convention. I say this with some trepidation because I don't know if we're mature enough to handle it. I think as a society we're very fragmented, but I think it would be healthy to have a more modern constitution. I don't think ours is God-given. I think it reflects a lot of important values, but I don't think it's cast in stone. I think we could have a new one, and I think it might be more reflective of where we are today. I don't know what that would look like, but until that happens, we have a written constitution. Judges take an oath to it. That gives them the power to issue decisions, right? What's the difference between a judicial decision and an op-ed, right? An op-ed, anyone can write, but only a judge confirmed by the process spelled out in this document can issue the opinion. So I think we're stuck with it for now.
Thank you to both of you. Now it's your turn to go first, Josh.
All right.
Does originalism require judges to act as historians, focusing on old documents instead of as judges, reasoning from precedent and notions of fairness and justice?
That's a good question. A common criticism of originalism is that judges are not historians and they shouldn't get involved with this. I think there's a difference between acting as a historian and trying to find the meaning of legal texts. That's something which lawyers are trained to do. And whether these are documents drafted in 2019 or 1787, I think it's a similar framework. Now, historians don't agree with this. They think the originalists are out of their league. But to use an example, we have patent cases. This is George Mason. And you go to a judge with a case about a complicated piece of technology, right? Are judges engineers? Most of them aren't. Maybe the Federal Circuit, but most judges aren't. Are judges chemists? Are judges biologists? How do judges learn enough? They make do. They make buy. So I don't think there's anything unusual about judges consulting historical materials. I think it's consistent with things that judges have to do on a common basis with their toolkit of skills.
So I think, yes? So I think it tells us something that most serious historians are dismissive of originalism. And the reason they're dismissive is because serious historians know that the past is ambiguous, uncertain, and in some deep senses unknowable. I think that a lot of work was done by a phrase Josh used in his main presentation. He said, what judges should do is decide whether something modern is the same sort of act as was covered by the Constitution. How do we decide what the same sort of act is, right? Is carrying an AK-47 the same sort of act as carrying a musket? Is running Google the same sort of act as a pamphleteer handing out printed pamphlets in the 17th or in the 18th century? There is not a determinate way of deciding that. The acts are similar in some respects, radically different in others. And so when judges decide whether something is the same sort of act, they're actually not deciding what the original public meaning of the law is, and they're not engaged in anything that a historian would recognize as historical research. What they're doing is exactly what originalists would say they shouldn't do. That is to say, they're making a value judgment about which aspects of the act to emphasize and which aspects to suppress.
Thank you again, both. And now back to Mike.
Now, do you want to maybe do questions from students? We have about 8 minutes left. Yeah, over there.
So if I may raise 2 points. So first,
Raise them louder.
yeah, okay.
Want to stand up? We will make it project. Thank you.
So the first is the alternative to originalism is living constitutionalism, and with that, an example is cruel and unusual punishment. Leaving aside capital punishment because that is mentioned in the Constitution. Public flogging was very normal place at the time of the founding. So if we were to use an originalist standpoint, would we still have to allow public flogging? Or would we have a living constitutional standard where cruel and unusual punishment is defined by the spirit of the times? And second, I'll let you respond, Professor Blackman, to one of Professor Bernstein's criticisms.
Of me? Of me?
Yes.
Oh boy. By the way, David Bernstein gave me an A- in common law. Never let him live that down. Poor judge of character if I ever saw one. He's a good friend.
But more of a religion. So originalists and textualists criticize people who rely on the intent of Congress, but then turn around and say, well, what was the founder's intent? And then in tempting the criticism of intent for Congress is that there is no one intent of Congress, but yet you try to form an intent of a bunch of founders who also may have been using Federalist papers to persuade citizens, and so maybe they weren't honest in writing Federalist papers. So what do you say to those two criticisms, both the cruel and unusual punishment and
Very, very good questions. Thank you so much for that. And David Bernstein's an old friend. I sat, not in this room, I was 215 right upstairs. I common law. You remember what room you were in for classes? It's crazy. I was right there for common law, so it's a little bit eerie. This was my Civ Pro room in Contracts 1 room. So the first question on the flogging. We don't need the Constitution to get rid of really dumb stuff, right? I think society abandoned flogging long before the court took up the 8th Amendment, right? We can get rid of dumb stuff through the democratic process, right? There's nothing saying you have to engage in it. Now, in the 8th Amendment in particular, you gave a very good carve-out. You said, forget the death penalty for a minute. The Constitution specifically countenances death, right? That if your life, liberty, or property can be taken with due process of law. So the argument that the death penalty is always unconstitutional is a tough one to sell. But the phrase is cruel and unusual is somewhat of a unique phrase, and it's not one I spent a lot of time considering. But the phrase cruel and unusual may be a unique outlier that requires you to consider modern circumstances in ways other provisions don't. This is not my area, so I won't go further than that. The second question, I think I understand it, is about original intent. I'll use an easy example. Scalia hated legislative history. He hated it, right? Because the people don't vote on it, right? It's these committee reports written by staffers and lobbyists. Congress is a they, not an it. There are lots of people. How do you aggregate the intent? Most originalists accept that much, that we don't look at original intent, we look at original meaning. But there are different things that are evidence of original meaning. You have the Federalist Papers, for example, which were advocacy documents. They were op-eds, basically, persuading people to write the Constitution. Op-eds aren't always objective. But you check the anti-federalist, right? You check letters, you check documents, right? You use corpus linguistics. You can use a much broader survey to see how various words are used across the board, right? For example, the word commerce, right? The Federalist Papers trying to sell people on a national government. I think the use of the word commerce perhaps maybe was shaded by that, maybe it wasn't. Then you check the anti-federalist papers. You check state statutes. You take federal, or not federal, but you check congressional statute at the time for the Articles of Government, right? There are lots of sources you can use. So I don't find either criticism devastating, but I do think it's worthwhile to ask, what are we using to do originalism? I think that's a worthwhile consideration. Michael?
Okay, got to get this right. Yes?
Good.
Yes. So first of all, on just a minor point on the Constitution recognizing the death penalty, it turns out the Constitution also recognizes the propriety of cutting off people's arms and legs.
Limbs.
The double jeopardy clause says that a person shall not be held twice in jeopardy for their life or limbs. So the question we have to ask is, do we really want, in 21st century America, a determination made about whether you can, for punishment for a crime, cut off a limb to be determined by what people thought in the late 18th century. And contrary to what Josh says, this is not just sort of a hypothetical question. It turns out that a number of judges in various parts of the country have ordered people convicted of sex crimes to be castrated, to have their penises cut off.
Well, no, I think it's chemical castration.
No, some of it is surgical castration. Some of it is chemical. So it just, I have to say, it seems quite bizarre to me to have that question determined by what people thought 200 years ago. Why not? I would rather have the people of France decide that, frankly.
Would you use a guillotine? Sorry.
Sorry.
So,
moving on to another hypothetical. I noticed that a lot of the men in the room were crossing their legs right now.
Couldn't help it.
Let's talk about. So Josh.
I'm done. Mic drop. I'm done.
Josh mentioned Brown. And he's right, there is a debate between law professors about whether Brown is consistent with the original public meaning. I happen to think Klarman gets the better of it. But here's the real point. If you're an originalist, then what you have to say is your support of Brown is hostage to which of these professors is right about what people were thinking in 1868. And if you show me convincing evidence that actually Klarman is right and McConnell is wrong, then you have to say Brown was wrongly decided and it's perfectly legal for Virginia to segregate its schools again. So I'm going to use a technical legal term to describe that position. It's nuts.
That was an ineffective mic drop, by the way.
And on that note, we have reached our time. Thank you both
Thank
very
you.
much, and thank you to the audience.
Thank you. That's good. Thank you, Ross. That's fun.